As some of you will know, I'm a law professor here, and I do Aboriginal rights in domestic and international law. I don't actually do criminal work or Gladue work. So I'm kind of thinking, why am I here? And so why am I here? It's because I did some research with Legal Aid Ontario trying to improve resources available to legal aid lawyers in Ontario working with Aboriginal clienteles to increase competency of legal aid lawyers when they're working with Aboriginal clients. So what I'm trying to present here, and I'll try to be quick, is some of the strategies and initiatives that they've taken in Ontario to improve competency. And I have a slideshow, and it's very sort of text heavy, but these are going to be available, so I think I might just highlight a few points so that we have an opportunity to ask questions of our guests who are here. So first off, in Ontario, there was in 2007 direction from the Legal Aid Ontario Board that legal aid needed to take steps to improve, they use the word measurably improve, Legal Aid Ontario services to Aboriginal people. And there's a definition there, and I'm going to come back and hit that in a second. And why did Legal Aid do this? Is because they also recognize that given the extreme overrepresentation of Aboriginal people in the criminal justice system, and the many other forms of systemic oppression and discrimination faced by Aboriginal people, Legal Aid Ontario is committed to providing better legal aid services to Aboriginal people. And when I was speaking with their policy council today in doing my final preps for this talk, she said they do really see it as a quality assurance policy, that if Legal Aid Ontario is going to provide certificates and funding for lawyers to represent Aboriginal clients, they need to ensure that those clients are receiving quality legal services, and that includes people knowing about Gladue and knowing how to make those submissions. So in the original report that they started their discussions on, they listed 12 initial action items, and you can see that the 12th one allows for refining. And so my work with Legal Aid Ontario on this strategy was really about reviewing and improving the resources that are available to legal aid service providers. But I can say that they've actually hit a lot of these points, and I'm going to try to highlight them briefly in the few minutes that I have today. And this is an awkward setup, is there? Okay. There we go. Now I don't have to do this side step every time. Okay. So one of the things that they did that I think is really exciting and important is that they now ask every person who applies for legal aid whether they identify as a First Nations, Métis, or Inuit person. And I think this is one of the things that's sort of been hit upon today and is one of the issues, is that I think sometimes people thought, oh, I know an Aboriginal person when I see them. I can figure out who's Aboriginal and who's not. And then there was also, I think, some misunderstandings that's already been hit upon about who Gladue applies to the definition of Aboriginal people. But they also talk about status and non-status Indians. So people that may not fall under the Indian Act are afforded Gladue privileges. And then also they make references to reserve and off-reserve members. So I think that definition is really important, and we need to think about how we ensure that Gladue, if and when it's developing, is an inclusive definition and hitting all the people that it needs to. Another thing that they did, and this is a brochure that's available on their website, and I've got the little link there, but as part of the addressing the concern that you might be perceived as racist if you ask your client, are you Aboriginal? They produced information so that before you ask the question, are you Aboriginal, you can provide some information to the client. I'm going to ask you if you're Aboriginal, and you have the opportunity to tell me, and these are the reasons why. This is what this might mean for you. And so I think that helps address some of those concerns. The second thing that was a big point in the 2008 and 9 initiatives was offering an extension of legal aid certificates to cover Gladue submissions so that legal aid lawyers could apply to Legal Aid Ontario to receive additional funding so that they could make these submissions to the court. And I think that was probably quite an important part for the lawyers working in that area. Another point that they started around this time was they created and have started delivering since 2008, 2009, what they refer to as Aboriginal cultural competency training. And so this is, I think, for legal aid, that point where they are trying to educate lawyers about the systemic issues that are facing Aboriginal people. This idea that they actually, that the judges or the lawyers, that they know Aboriginal people and they know the history, they know what's going on. My friend was saying when she delivers these workshops, people say, oh yeah, I had heard about residential school and I kind of had heard about this, but no one had ever taught them in their lawyer training how that impacts our communities and what this word intergenerational effects, what that actually means and how we need to trace individual offenders through this system of Canadian colonial and racist policies that were set out to destroy Aboriginal people and how that impacts the clients that they're dealing with. And so I think, again, a big point in education, and I think while I can say this is something that lawyers that are practicing need to learn, I think that's something that we also here in the law school are starting to realize, that we also have that responsibility that when we're training lawyers, we need to ensure that our students are having this information. So I've got this slide, LAO law, but I'm going to skip it just to sort of say some of the work that I did. LAO law is it's a resource that is provided through Legal Aid Ontario. So they provide memorandums on various issues that they provide funding for. And these are research memoranda and sample facta, etc., that are available to all legal aid lawyers. And so as part of the initiative, what Legal Aid Ontario did is said, well, we currently have 3 memos on the Aboriginal section of our website. Can you go through and find all the other memos that might exist in our system that are related to Aboriginal, working with Aboriginal clients? Make sure that they're culturally appropriate. So when we're referring to people, we're not being condescending or we're not using inappropriate or offensive language. And then also make sure that they're up to date and using the most recent case law. So this was work that I did in 2008, and I understand that they now in the LAO law offices, they have people that are dedicated to ensuring that these research memoranda are up to date on an ongoing basis. And it wasn't for them just a one-off hiring me in 2008, doing a contract, doing this updating, and then leaving them sit for another 10 years. They actually are continuously updated. I also did some work updating the website so that on the Legal Aid or LAO Law website, they have a list of resources. Where can you go to, like, who are the political and territorial organizations in Ontario? Who are the people that are providing some of these services? So there's also just links to other places that lawyers might want to refer to get this information. I think I'm not going to talk about these too long because we're almost out of time. And I think the last thing that I want to mention that Legal Aid Ontario has done is this panel standards. And I'm not actually that familiar with the Manitoba system, but I don't think we have the paneling process here. But basically, the Gladue panel is an indication that lawyers have extra competency in a specific area. So it's a recognition of expertise. And so they've had criminal, they've had family, Jonathan, do you know all of immigration, etc. So that lawyers can actually be designated by Legal Aid Ontario as having certain expertise. So they've created a Gladue panel. And so it's actually quite a simple process. The expertise isn't setting the bar extraordinarily high. You don't need to be the #1 expert. You don't have to be Jonathan Rudin to be have Gladue panel indicated. But it is going to raise, again, that minimal competency. So it says you have to be a member of the criminal panel. There's mandatory legal education, and so you have to review the legislation. So that would be both the provision that we've talked about and also the equivalent provision for the youth justice system. And then some case law, and I think I have the cases. So I think they're requiring at this point reading Gladue, Kekagamak, and the Batiste case. Then you have to be familiar with the memos that are available. So you have to have read through the research memos, and these are on topics. So the memos of Gladue sentencing submissions and also the application of Gladue to bail hearings. And then you also have to become familiar with the resources for Aboriginal clients in the local area where the applicant is practicing. And then it says you also have to comply with the expectations set out in the Gladue panel members document. And these include things like knowing the rules of professional conduct, maintaining a familiarity with the services to assist Aboriginal people that are available in the courts and communities. You have to be inform the client of Gladue principles and the application to the client's case, and then maintaining the solicitor-client relationship in accordance with the rules of professional conduct. The panel member will protect the dignity of the client, respond promptly to reasonable inquiries from the client, provide the client with the necessary information to make informed decisions respecting his or her representation, respect the client's instructions fully within the bounds of his or her professional obligations, advance the client's position, and maintain solicitor-client privilege. So I think some of the things that are hitting on there are things that we have discussed today. This idea of protecting the dignity of the client. I think for me, part of what I would hope that would encompass is we saw the types of information that's coming out about the individual person's background and history. And one of the things I spoke to Jonathan about on the break is my concern that we're now required to put all this information on record before the court. And when I was doing this research, I was reading these decisions, and the things I was able to find out about these people, it's just not appropriate. That shouldn't be in the decision. So I think part of the protecting the dignity of the client can include that you make the submissions to the court, but it doesn't mean that the judge then needs to write out that this person was abused by this person this many times at this different stage of their life, and then their father did this to them. We don't need to have that on in the written decision. So I think that would be part of protecting the dignity of the client. And then also that, how do you really presenting the options to the client? Do they want to engage in, attend the Gladue court if they're in Toronto or one of the other sites, or do they want to waive their right to have Gladue principles considered? And so I think it's part of that is having that meaningful conversation with your client and, speaking for them with some sort of understanding of what the client truly wants because you've informed them of their options. So I don't want to sort of weigh in whether these are good or bad requirements, but I think it is something to think about is not just what are we doing in the courts, but what are we doing to ensure that lawyers who are engaging in criminal practice, both from the Crown side and defense side, are actually competent and prepared to make appropriate Gladue submissions.